Hello and welcome to Protect Your Copyrights with Red Giant Rights Group CEO Robert King. On today's podcast, Robert dives deeper into why you should protect your copyrights and what the process looks like. And now, here's Robert King with Protect Your Copyrights.
Come on! Hey everyone, thanks for joining our podcast, Protect Your Copyrights. My name is Robert King. I run a company called Red Giant Rights Group. We started it with the older artist in mind, those older artists who were not aware of all of their rights, particularly given to them by the U.S. Congress. And we also assist surviving family members, most of which don't have any inclination of their rights. They were not artists. They were not in the industry. They have wills, trusts, and estate attorneys handling their estates who know very little, if anything, about copyright law. So we hope that you'll check out all of our podcast episodes and learn what you can. Feel free to reach out to me personally, but let's see what we'll talk about today. Hello, good morning, good afternoon, good evening, wherever you are, whatever you're doing. Thanks for tuning in and listening to the podcast, Protect Your Copyrights. So today we're talking about why. You got to answer the question of why. Why in the world do you go through this process? Why do it? Why protect your copyrights? And the immediate response, immediate response is, why not? You know the old adage, or when we were kids, and our parents or whoever used to say, are you gonna get involved in X, Y, and Z? Did you do it because little Peter down the block did it? Why did you do it? Well, because somebody else did. Well, that is a perfect reason to terminate your terminate your copyrights because somebody else did. You would maybe you'd be surprised, maybe you wouldn't be surprised, but there are plenty of folks out there who have gone through this process already. Now, remember, just to set it up, the law was passed, the copyright law was changed in 1978, the law was passed in 76, instituted in 1978. So one copyright statute applies prior to 1978, another one applies post 1978, and this is the way I understand it. I'm not an attorney. We use some of the best copyright attorneys in the country, but this is my understanding of it. So this wasn't a big deal. This wasn't on anybody's radar because the prior copyright terminations were two renewal periods of 28 years, which is 56 years. So that didn't come up till recently. And this one that started in 78 is 25 years. Doesn't even start till 25 years later. So just imagine, if you're in the 80s, you're not thinking about terminating your copyrights. 90s, you're not thinking about terminating your copyrights. 2000s, not really. It was only in the beginning of the 2010s, around 2013, was this really coming into the the awareness of artists as a thing, as something of significance. So therefore, you don't have a lot of, or not everybody knew about it. Not everybody was acting on it. And now, that was 5-10 years ago. Now we have a ton of artists who are aware of it and who are taking care of their copyrights and who are taking care of their responsibilities to protect their copyrights. And not surprisingly, more songwriters do than recording artists. Let's talk about a simple concept of copyrights. This is and this is one of the more frustrating topics for me personally because of how the law is set up, and whoever was in charge came up with this concept, and it's very frustrating to think about. But let me break it down for you as simply as I understand it. Something went into effect on February 15th, 1972. Okay, so prior to February 15th, 1972, a song, and we're talking about just songs now, prior to February 15th, 1972, a song had only one copyright, called the composition. That's the person or people who wrote the song. Okay, that was the composition copyright. Now, after February 15, 1972, every song has two copyrights: the composition, songwriters, and the sound recording artist. So, why? And one of the podcasts will dedicate an entire podcast to why in the world is the sound recording not a federal copyright prior to February 14th, 1972. But that is for another conversation. And as I just said, it's one of the more frustrating things that we deal with on a daily basis. So if after February 15, 1972, your every song has two copyrights, then that means that the new law, the new statute that went into effect January 1st, 1978, has two copyrights. So everything that falls within the new statute has two copyrights: sound recording, compositions. Now back to why would you do this? Well, because there are a whole lot of other people who are already doing it, and they're household names. They're major recording artists. They are some of the best and well-known songwriters of all time. And not surprisingly, there are more songwriters who have gone through this process than recording artists. And that's that composition sound recording type thing, right? You understand having your own publishing company. You understand sending in copyright notices into the copyright office for your written work, for your composition. Not everybody gets that you're also making a copyright with your sound recording. So, is it up for debate whether or not you actually own the sound recording, whether it was a work for hire, whether it was you were part of a corporate body, blah, blah, blah? Yeah, of course. Yeah, it does, a little bit. But I'll argue all kinds of things on that. And we'll go back and forth on that. And federal case law is not necessarily do they have a decision yet on that. So we can argue back and forth. And some labels feel very strongly one way, and other labels feel strongly another way. So Every label has their own argument. So you just gotta know that going in. They're not interested in giving you your sound recordings back, and frankly, as far as our experience, very few people are getting their sound recordings back. Compositions, on the other hand, songwriters, yeah, they have a much better chance of getting their compositions back. Sound recordings are their own different animal, and we fight that battle every single day. But one of these days there will be a decision that will, by the courts, that will help define this, and that will provide some clarity, and that hopefully will help the artist. Hopefully will solve the problem for the artist. That would be a great day, because the recording artist deserves, just think, we talked about this before, but you're talking about a copyright that's 25 to 35 years old, and if it's still out there, every asset is valuable, so don't get me wrong, but if a sound recording is still out there making money 25 to 35 years later, give it back to the artist. Goodness gracious. The record label has made their money. They have made their money and then some. They have made their money hand over fist if it's a popular song. So that's what we're talking about today, is who else is doing this? Why wouldn't you do this? We did some research a couple of years ago, and just to find out, just to look at sound recordings and songwriters and recording artists, and we found that the songwriters were about 50-50. The popular songwriters who had gone through this process was about 50-50. Recording artists was about 70-30, meaning 30%, only 30% had started this process. Now, how do we know this? It's really it's common knowledge. Anybody can access this information. We may know how to access this just because we deal with it every day better than most, but it's common knowledge. And I don't like to use a lot of artists' names just because because I'm in the copyright business and I understand the value of name or likeness. So I don't necessarily want to use somebody else's name, an artist's name, when I know that it's when I know it's an important thing to protect the names of people. So we're not gonna give you a long list of names. However, I will tell you, let's say this: in America, American artists on the sound recording side, I would say over 100 have started the process of terminating their sound recordings. Again, household names, some of the top recording artists of all time. Songwriters, hundreds. Easily. Hundreds. And the interesting thing about songwriters is that many of them started this process decades ago, because they wrote songs in the 30s and 40s and 50s, and they started the term is 56 years, and so they started sending in their notices of termination decades ago. So songwriters, hundreds, and sound recordings, I can identify, we can name over 100 in the U.S. And what's interesting is there are artists, recording artists from all different kinds of countries all around the world that are executing their termination rights. Now, keep in mind that I'm not an attorney, but as I understand it, when you terminate, you only get to terminate U.S. So no matter what, again, a loophole in the law that's very frustrating. You don't get if you terminate, you get your U.S. Copyrights back. You don't get the international sound recordings back. The rights to the international sound record, to the international sales. You don't get the rights back to the international compositions. They can keep exploiting those international rights for profit. So that's why in some instances it's better just to negotiate a new deal. And often more, I'd say more often than not, that's what Red Giant is trying to do on behalf of artists and surviving family members, is negotiate a new deal that's more fair. Is it fair altogether? No. No. But it's more fair, and it helps the artist and the family members for the next 30 plus years with new terms. So in that way, it can be a positive thing. So that's what we do at Red Giant. We in many cases it makes sense to renegotiate the deal, to renegotiate the entire thing. And is it always it is always a win for the client? Is it necessarily the preference? Is it fair? No. But is it better than what it was before? Absolutely. So those things are good, and that's what we're doing on behalf of the artists every single day. That's why we're out there trying to make a difference for these artists, songwriters, recording artists, authors, playwrights, screenwriters. So, sorry to interrupt. This is Robert King, CEO of Red Giant Rights Group. I want to make sure that you know that we are available to answer your questions. Feel free to call me on my cell phone for a confidential conversation. 917-848-9934. Again, 917-848-9934. And now back to the podcast. Why do you do it? Well, bottom line is because everybody else is. Not everybody. Because a whole lot of other people are. And specifically, when you look at some of the household names, greatest rock stars, greatest country music singers, greatest songwriters in pop, then you see that they have started this process or have finished the process. They have either negotiated their copyrights back, or they have negotiated a brand new deal. Now, let's say a couple more things. So you need to know that this is a process. This is the way I understand it. Again, I'm not an attorney, but the way that I understand it, once you send in paperwork to protect your copyrights, you're really giving the record label, the publisher, the production company a 2-year window, a 2-year heads up. You're really giving them 2 years to decide what they're going to do. And so it's a long process. It's not something that you call up Red Giant and say, "Hey, I want to do this, and next week we have an offer for you." It just doesn't happen like that. These multi-billion-dollar companies are slow. They are thoughtful. in what they're not thoughtful, not thoughtful in terms of considerate, but thoughtful in terms of they're going to review and examine every possible scenario and try to make it work out for them the best way possible. So it takes a while. Plus, now 5 years, almost 10 years later, there are a whole lot of people doing this. Let me just put in a small advertisement for what we do. Yes, can somebody else do this for you? Sure. As a matter of fact, you can do it yourself. You can go through this process yourself. As a matter of fact, if you will call me, I'll give you the link to the page on copyright.gov that tells you exactly what to do. You can do it yourself. And anybody who tells you can't do it yourself is lying to you. Now, will you have success yourself but doing it yourself? Don't know. Will you make a mistake that could cause you to miss your window altogether, or to have to start all over a year or 18 months into it? I don't know. Possibly. Well, one of the main things that we notice is there are a lot of people making mistakes. There are a lot of people that are, pardon my language, that are screwing this up. And so, yeah, you get to do it yourself, and you want to avoid paying somebody like our company to assist you, or more often than not, Red Giant. It has a piece of the negotiation. Whatever we negotiate, we're compensated through a percentage of that and a percentage of the copyright moving forward. So let's say you don't want to give that up. All right, well, you can do it yourself. You can find attorneys and pay them a retainer, thousands of dollars, to do it. Absolutely, you can do this yourself. Unfortunately, is if you make one mistake, you miss your window, and then it's done forever, gone forever. Unfortunately, you may not have a working relationship with record labels, publishers, production companies. You may not know the intricacies of the Copyright Act. You may not know exactly what to say, when to say, how to say it, and may not have leverage. And leverage is very important in this negotiation process, because you want the leverage to be able to say, hey, we're doing 10 deals with you, we're doing 100 deals with you. Let us, let's throw this one into the mix and make a difference. So that is, there are a whole lot of reasons why you would use a firm like Red Giant. If you want to use a different firm, go for it. We don't have to, you know what? Frankly, when we started this business, I started it with the artist in mind, and I wanted to. I'm an artist. You may have heard me say this. I'm not as good as any of you guys, but yeah, I sing, and I've released an album and a couple of singles. And I have, I'm working on an album presently, and I have aspirations of being a international superstar. Sure, all of that is true. Why did I start this company? Because I have a heart of the artist. I understand the artist's plight. I understand working so hard on something and being so, well, with all due respect, desperate for a recording contract that you would sign just about any document, and now 30 plus years later, let's go get value for that document. Let's go get value for those copyrights. So yeah, we believe in the artist. We have a heart for the artist, and that's what we're focused on primarily. So, can you do it? Yes. Will you make a mistake? Probably. Are there other people who can do it for you or with you? Yes, there are other firms. Will they make mistakes? All I can say is that we have spent time in the past solving the problems that other firms have made. So I'm not here to disparage any firm. I'm not here to disparage any attorney. There are fine attorneys out there who are doing this work. And so like I said, we use some of the top copyright attorneys in the country for different projects. So you absolutely can find somebody. What's a little different, this is not a commercial, but just know that Red Giant has a series of services that go above and beyond filling out the paperwork, because, like I said, anybody can fill this paperwork out. You can fill this paperwork out, but you want somebody who will, or a firm, a group of people who will do this more than just filling out paperwork. They will offer more services than just filling out paperwork. Okay? To wrap up, I want to just say a couple of things. Why do we do it? Why in the world would we go through these steps? Because a whole lot of other people have, and they're your contemporaries, or they're better. They're more successful. They, I'm talking about some of the biggest names of all time. I can use names of the people who have the popular filings, suits against the record labels and publishers, like Paul McCartney. And Paul McCartney and Sony ATV had a settlement several years ago, and one of the reasons Paul McCartney sued was because he'd sent in notices of termination and Sony ATV wasn't doing anything. Now we can argue that about the timing of everything, but the point is that he knew he had rights, and that's why he terminated. And if you're sitting there saying, well, of course Paul McCartney did, he has assets, and that's why he went through the process. Sure, he has assets, and so do you. Every creation is an asset, and it's up to Red Giant or whoever your partners are to find out how to use those assets to your advantage and make the most money that we possibly can for you and your surviving family members. But don't use the excuse of, well, I'm not as big as Paul McCartney to not go through this process. I guess just about everybody could use that excuse, but there are plenty of those out there that are one-hit wonders, that have 10 number ones, that have released 40 albums. It's just, it doesn't, the range is massive. There's one artist that released one album, maybe just a single, but released one album, had one hit single, and he terminated. Why? Because that particular song, makes a ton of money still, and is great for syncs, and great for licensing. And so you want to make sure that you have as much of the rights as possible. So take the concept of, if these other people are smart enough to go through this process, there is a reason why they've done it. There is a reason why you should do it. And it's not a peer pressure thing. Oh, just because they did it. No, it's because you have been granted these rights, this gift, by U.S. Congress. It is federal law. Let me use another quick example before we wrap this up. This Duran case that the ruling came a couple of years ago, that's brutal. It's just absolute. If you spent some time looking at the case itself and the details of it, you would understand why it's so frustrating for a guy like me, because it just sent the wrong message to particularly to English artists. There are dozens of artists outside international artists who have submitted notices of termination for the U.S. rights, and it just makes sense that you do it. But this Duran Duran case sent a message to saying, "Oh no, you don't have the rights to do this," and it is hopefully somewhere down the line there is a new ruling on it. Hopefully somewhere down the line, it's the record is set straight, but it has been an impediment to some English artists or international artists taking advantage of their rights, of their U.S. rights given to them by U.S. Congress. And so that if you are one of those artists, if you are a surviving family member, you still have these rights. Don't let anybody tell you don't. There are other English artists who are exercising their rights. Don't let anybody tell you they're not. So, look, here's the bottom line. Can you do it yourself? Yes. Go for it. Absolutely. When we started this business, I had the heart of the artist, as I told you. And so we're agnostic on whether or not you choose Red Giant. We really want you to take care of your copy. The whole concept behind the podcast is protect your copyrights. We really want you to protect your copyrights for yourself and for your surviving family members. And we've talked about how long that is, right? Prior to 1978, those copyrights are good for 90 plus years, in some cases 100 years plus. These copyrights after 1978 are good for 70 plus years after for the rest of your life plus 70 years. So this is generational. These decisions that you make in order to protect your copyrights can have impact on your family for many, many years. And we have those clients. We have those family members who are still making the gift is still being given, who are still making money off of the copyrights from their original from their father or their mother, brother or sister, from their family member. So this is you can do it, but if you're going to do it, choose a firm that you can trust, that you believe in, that's had success, that potentially like Red Giant can offer you additional services besides just writing a letter. And think about the fact that why wouldn't I do this? Why would I not try to protect as much as I possibly could and take advantage of something that take advantage of something that so many other people have, so many other songwriters, so many other recording artists, so many other authors, playwrights, screenwriters. Protect your copyrights. Thank you so much for listening today. As you can tell, I feel very strongly about this. It's a passion for me, and I just want you to take care of yourself and your family members. Let us know how we can help you. Thanks for listening. I look forward to speaking with you again.
Thanks for listening to Protect Your Copyrights with Red Giant Rights Group CEO Robert King. For a confidential conversation with Robert, give him a call on his cell phone at 917-848-9934. Once again, that's 917-848-9934. 9934. We hope you enjoyed this podcast, and be sure to join us next time on Protect Your Copyrights with Robert King. Woo!